Welcome to everyone. My name is Annette Desmarais, and I'm a Canada Research Chair in Human Rights, Social Justice, and Food Sovereignty. And I'm an Associate Professor in the Department of Sociology and Criminology at the University of Manitoba. Now, it's a great pleasure to welcome all of you to this panel discussion entitled The UN Declaration of the Rights of Peasants and Other People Working in Rural Areas, UNDROP for short, and what it means for Canada. So I want to start by acknowledging that this event is being hosted by the University of Manitoba, located on the original lands of the Anishinaabe, Cree, Ojibwe, Dakota, and Dene peoples, and on the homeland of the Métis Nation. And it's being held 150 years after the signing of Treaty 1. So today's panel is part of a series of events organized by the Center for Human Rights Research here at the University of Manitoba. And the panel was co-organized with the National Farmers Union, Food Secure Canada, and the Canadian Association for Food Law and Policy. So we thank the co-organizers for their participation in putting together this event. The event is being recorded and it's going to be available on YouTube. People will be able to search the Center for Human Rights Research and find the video there. So on the 17th of December, 2018, the United Nations adopted the Declaration of the Rights of Peasants and Other People Living in Rural Areas. Now, for peasants, Indigenous agrarian communities, rural women, and farm workers around the world, this was truly an historic accomplishment. The three speakers today that are with us will shed some light into what the Declaration is all about, why it's so important, and how it can be used to help transform the existing global corporate-led industrial food system, how it will help to transform that food system to more socially just, ecologically sustainable food systems. So we had planned to have 4 speakers today, but Priscilla Clays from the Center of Agroecology, Water and Resilience at Coventry University is unable to make it today because she's ill. So she sends her regrets and we will miss her. So I'd like to just proceed.
What?
Annette, oh.
Okay.
You got it.
Was I muted all this time?
No, just for a moment.
Okay, I have no idea how that happened. Okay, so what I'm going to do is introduce the 3 speakers, and then we'll have a conversation among the panelists if they have any questions for each other, and then I will open it up to the audience, and you're welcome to actually send the questions in through the chat. Okay, so our first speaker is Geneviève Savigny. She is a peasant farmer in southern France. She is an active member of the Confédération Paysanne, which is a member organization of the transnational agrarian movement called La Via Campesina. Actually, maybe I could ask everybody to mute themselves right now because I'm hearing somebody typing away. So as a representative of La Via Campesina for Europe, Geneviève played a key role, a leadership role in the negotiations of the UNDROP. Now we've given Geneviève a very, very difficult task. She has 15 minutes to explain why peasants demanded this international declaration, what rights are covered, and why it matters. That's a hard task to do in 15 minutes. She will then be followed by Jessie MacInnis, who is a first-generation agroecological vegetable farmer based in unceded Micmac. Jessie's farming journey began 7 years ago after finishing a BA in International Relations at Mount Allison University. She knew that politics and social justice were deeply interwoven with her own desire to grow food. So she became involved in the National Farmers Union and also in the Via Campesina. She is currently the Youth Vice President of the NFU, the National Farmers Union. She is an active member of the Via Campesina's International Peasant Rights Collective. And she's also involved in the civil society and indigenous peoples mechanism that's based in the FAO, and that's within the youth working group. She's currently actually completing a Master's of Human Rights at the University of Manitoba. And our final speaker is Nadia Lambek, and she is a Doctor of Jurisdictional Science. She's a candidate for her doctorate at the University of Toronto, and she is also a human rights lawyer. She is a researcher and advocate focusing on food system transitions and the rights of working people. Her current research explores how the law and legal claims are framed by transnational agrarian movements and how law can and cannot be mobilized in the pursuit of more equitable, just, and sustainable food systems. In particular, she looks at the claims for the rights to food sovereignty and peasants' rights and the possibility and limitations of institutionalizing these emerging rights in domestic and international fora. Nadia was also the advisor or an advisor to the former UN Special Rapporteur on the Right to Food, Olivier de Schutter. Now, with those introductions, and again, I welcome all of you, and just remember to keep your questions or post your questions in the chat. And I will call on Geneviève now to begin her presentation.
Yes, good evening, everybody. In fact, it's evening here in France, and I'm really happy to be with you so far away. I hope you can hear me well and see the slides well. We had some technical problems, but I hope everything will turn out fine. Well, to say I'm a leader maybe is too much. I was part of the team that went on the process for a long time, but I was not at the origin of the process, as we will see in the presentation. So if someone can put the presentation on the screen, I'll be happy to comment from my place. Okay. So yes, next please. Well, I'll be very short on that one. You probably know Via Campesina better than I, but it's just to get into the topic that it's a big organization struggling for food sovereignty, agroecology, seeds, and representing 182 local organizations in 80 countries. So we can feel very proud of this, and that makes us feel big when in our countries, in Western countries, our organizations are not so, don't have so many members. So next, please. So my the organization I've been really involved in is the European Coordination Via Campesina. That is the European part of Via Campesina. And we are dedicating our lives on common agricultural policy, but not only, as we are also involved in, well, FAO processes that are international processes that we are also working on, but also defending food sovereignty, agroecology, and the different rights that we are now also trying to implement. That is right to seeds and right to land. That and we will be able to go a bit later on around it. So this is one of the buildings of the European Commission, the main building of the European Commission, which is called Berlaymont, and the demonstration in front of this building against TTIP and CETA. So it's a demonstration in Brussels. Next, please. So why it's useful? We will see throughout this presentation how we are using peasant rights really as a backbone for different struggles. And this was a demonstration for seeds and against patents on seeds and backed on this question of the peasants' rights. So again, a demonstration in Brussels. So next. Now I'll try to summarize, but briefly, how we managed to achieve this declaration on the rights of peasants at the United Nations. It really started from SPI, which is the Indonesian organization from Via Campesina, and especially Henry Saragi, who was really involved right from the beginning. He was a farmer, he is a farmer, and he was also a lawyer. And he was trying to find out how to support farmers, how to defend peasants with international instruments, as they were facing really bad times in Indonesia with land grabbing and forced evictions. And so he went to Geneva to find out how they could handle this situation and how they could have some support in the international instruments. So they got support from FIAN, International Organization for Food, and CETIM, Geneva-based organization, and other social movements and academia. During several years, with Via Campesina and FIAN, they wrote reports about the violations on the rights of peasants, and it was presented in front of the Commission on Human Rights in Geneva. And in parallel, there was internal work to see what could be the peasants' right, what rights do peasants need. And it was discussed internally in Via Campesina, and especially in 2008 during the international conference that took place on human rights specifically. And in Jakarta, a bit later, a document was approved at the international conference of Maputo. Then it was agreed as a basis for the rights that peasants should have. In 2008, there was a big food crisis that you may remember of, and there was a presentation of the situation in front of the United Nations during the General Assembly in New York, but also in Geneva, made by Via Campesina at the Human Rights Council. And it was really important to trigger off some further work, because at that moment the countries began to think that food was important, that something had to be done to support peasants as food producers. And so that was really the beginning of these efforts being taken into consideration in the international fora. Next, please. So in 2009, the Human Rights Council gave a mandate to the Advisory Committee, which is a committee of experts, independent experts linked to the Human Rights Council, to carry out a study on the discriminations that peasants suffer in the context of the right to food. And this final study was presented in 2012. I make it very short because there were some intermediate studies and presentations and different steps before it was presented in 2012 at the Human Rights Council. And there was a proposal for a mandate and to work on a special instrument. So maybe in the meantime, what was the result of the study? That was really, indeed, there was a problem. There was an issue with peasants being discriminated with specific poverty, and especially for women and girls. But also it was not only the question of peasants, farmers, but also other food producers should be included, like small fisher, pastoralists. And this is also how it was enlarged, not only to Via Campesina, but also to some other food producers organizations like the WAMIP for pastoralists of indigenous people and people and different organizations that could join this struggle. In September 2012, there was a resolution passed at the Human Rights Council to establish the first open-ended intergovernmental working group. That's this silly owing, and to start negotiating, finalize, and submit a draft of a declaration. And the declaration that had been drafted by Via Campesina was attached to it, so it was already backing the work. The official work was backed with the work of Via Campesina. And Bolivia government took the task. That means that they would be the chair rapporteur of the oncoming work. So maybe next. So it's really a long road because it's a really step-by-step process, and there were 5 sessions of open-ended working groups at the Human Rights Council in Geneva. So you had the first one was in 2013, and this is really when I stepped into the process. As my farm is not that far from Geneva, and also I'd been involved in different processes at international European level, and I was invited to participate to this first open-ended working group. Very surprising and interesting to see also how to present how it was relevant, how human rights was relevant to European farmers, as we face the same problems, to put it basically. So each time you have a working group, then afterwards you need to have a resolution discussed by the Human Rights Council to continue the work and decide on how should be the continuation of the work. So it took really several years. And each time there was either a working group or a resolution at the Human Rights Council, which takes place, I think, 3 times a year. Then we would go try to organize a delegation with peasants, fisher, indigenous people to contribute to the discussions, which was quite different from what usually happens, because sometimes it's only NGOs, but in this situation, really peasants got involved, and the work we had to do with our governments was also part of the process. So it was not only to achieve something, but the way to achieve it also itself was both training, but also information on this international situation, what's happening, how to lobby, but also to explain to our government why it was so important for us to have this declaration. And for us, it was because we have the same problems, but also because European farming, and I guess Western farming, influences the rest of the world with its kind of model, which is proposed to the rest of the world. So in September, the last working group was in April 2018. In September 2018, it was adopted, the declaration, and a resolution to support the declaration in New York was voted in Geneva, and then it was approved at the General Assembly in New York in 2018. I must say we were really very, very happy and pleased, and although I couldn't go to New York, we were really so strongly linked to our colleagues who were presenting it and trying to always make some work to have as many countries as possible to vote in favor of this declaration. So maybe next. Next, please. So here is a part of the. Sorry, maybe back to this is the Human Rights Council in Geneva with the beautiful ceiling and different, well, all the delegations from different countries, organizations, from India. Ramona was from Romania, and from different organizations, and this woman from Bolivia. So it's really very, very strong commitment of a team that went along on the process all the time. And then we have the final result, and that's the next slide, with the result here in New York at the General Assembly. And as you can see at the bottom, we had 121 votes in favor, but representing a vast majority of the population of the world, because you have very big countries in these voting countries. 8 votes against, and of course, United States of America, and England and Australia and some others, and 54 abstentions, including Canada, who abstained, like many of the Western countries and European countries. For many of them abstained, and some didn't vote. They were not just present. Maybe next. So what do we find in this declaration? So it's a big, well, it's not that big a document, it's about 10 pages, but with 28 articles, including different rights. So you have kind of, I would say, general rights, the rights that are universal, like political rights, cultural rights, and social rights, that are all, but they are all detailed so that it can be used as a tool for peasants themselves. We can use it as something. It's not very easy to read, but it's possible because it's rather concrete. We don't have the titles, and that was one of the results of the negotiations, because, for instance, the countries didn't want us to write the right to land. They wanted us to write access to land. Countries that were against this process, they would insist on saying, no, it's access to water, it's access to seeds, it's access to land. And they said, no, we want the right to land, because this, otherwise it's not a declaration on the rights of persons. That would be just a declaration on the access of people. So that was part of the discussion. And at the end, what we have written like this, the right to is not, the titles are not present in the declaration, in the final text. You don't have the titles. But we, as a working document, we find it very interesting to have all these kind of rights really written. I'll give a detail on, maybe I will just insist on one point, that definition of peasants, very important to have a definition of what is a farmer for us, someone who is a producer, who wants to produce to get alone or in community, and engage in different activities. Because it is also something different from the professional definition of, I would say, mainstream farming vision. So it's quite important that peasants is written as such in the declaration, although some countries didn't like it. I will insist later on the question of land and seeds, but you can see all these rights that are written and that can be really important in some situations, like the right to be represented, the right of associations, a right to participation. You have a special also Article 4 on the question of women, and the question of right to health, the right to water, the right to social security, all those rights that make a life of a peasant livable. So this is really a full set of rights. Maybe some parts are not as strong as we would have liked. For instance, food sovereignty is just mentioned as a concept that is used in some countries, but it is not strongly stated. But it was already a victory that it is stated, so that it's one of the official documents that lawyers later can refer to. So that is the whole set of rights. And maybe I will go back on a couple of rights if you want. Next, please. So I will insist on 2 articles, like the right to land, which is Article 17, and 19, right to seeds. So land, maybe next, please. So So it also gives you an example of what is written. So if you remove the title, which is not on, then you have the first article, that peasants and other people living in rural areas have the right to land individually and or collectively. This also is a big victory, because Western countries, they don't like collective rights. They think individual rights. You are individuals, but they had to admit that it represents something in many countries. I will maybe move to the next slide, because I don't, and you tell me when I have to rush, because otherwise I will develop maybe too much. So you have this right not to be protected against displacement, and the rights to return to land. And what is important, and this is why it's been in red, it is in red, it is the question of the land agrarian reforms, and that states have to take, they shall take appropriate measures to carry out agrarian reforms in order to facilitate the broad and equitable access to land and other natural resources necessary to ensure that peasants, etc. So this is a very important article, especially in some countries. And next, please. You will see. So this was done by Ramona for Romania. So because it's mostly most important for Eastern countries. So Eastern countries, Eastern Europe countries like Romania, Bulgaria, Ukraine, they were very, very happy, very satisfied to see this declaration, because for them it's most important to have some support as they are disappearing rapidly with large estates growing again and again. So this was how they would implement it and they discussed about it in different meetings in Romania, Ukraine, and to see how to move on with this question, which is vital. Next one. Yes, so the question on the right to seeds is also at the core of our activity, especially as because the industrial seed system is really spreading all over the place and trying with these different patterns and is to forbid farmers to save, use, exchange and sell their farm seeds or propagating material. So this is really a crucial article, and it was really very carefully discussed, so that it really is a good tool, in different places where it is discussed, whether at European level, where they want also to have a new, there's a discussion, for instance, in Europe about new breeding techniques. As for the moment, they are not labeled as GMOs, but there's been a court case that they are GMOs. So it's really being implemented at the moment, at the very moment. So here is the law on seeds. So maybe next. Next again. Oh, a nice picture from Romania. Next. So for us, we have 3 key policies, and the CAP, where we will fight for, I would say, income, the right to income for small farmers, and the right for small farmers to have decent access to policy. In the process of the United Nations, we will be really concerned, we are very concerned at the moment with this United Food System Summit that is being developed outside of the normal processes of the summit that took place before. So for us, it's more a threat than a good. Yeah, sorry. And so that's maybe one of the, and like I said, of course, on the right to land and the right to seeds, that are very, very important processes that we are working on at European level. And we really use it as a backbone, as I said before, to support all our struggles for better life and better food systems. And the 2 last one, we can't forget about them. So I've finished.
Okay, thank you very much. Am I unmuted? Yes. Thank you very much, Geneviève. And maybe we'll be able to come back to those last slides after the other two speakers. Jessie, can I just ask you to jump right in, please? Thanks.
Of course. Let me organize myself. Great. Can everybody see my screen?
Yes.
Perfect. Love when it's easy. Okay. Hi, everybody. Happy to be here with you today. Thanks for joining. And thanks, Annette, for the introduction, and to Geneviève for that excellent recap. I know it's a lot to cover in a couple minutes. So as you can see from the title of my slide, it's also kind of the working title of my research project, which is analyzing the Declaration of the Rights of Peasants in a Canadian context as we work towards rights-based agriculture policy. So why am I studying this? Essentially, I'm trying to make the case that there's a place for rights-based legislation in Canadian agriculture policy, and that many of the rights violations, often assumed to be closer associated with lower income countries, are actually well and alive here in Canada as well. Oh, okay. It says my screen sharing is paused. Can you still see my screen? You can? Okay, cool. So in my opinion, the Declaration on the Rights of Peasants is really the best holistic framework to address the rights violations that the peasant farmers and farm workers in Canada are experiencing today. And at this point in my research, I must say that I feel I have more questions than answers, but I'm hoping to dive deeply into making strong connections between the articles and policy change proposals at the national and provincial level. So just to situate myself again with this research, I'm in a bit of a unique position because I am a farmer and I'm also an active member of the Via Campesina and a student right now. My first introduction to the Declaration on the Rights of Peasants was actually during the adoption process. I spent 2 weeks in New York in 2018 lobbying, and so I had to get well acquainted with it quite quickly. And from then on, I've been kind of working on it at an academic and national and international level. My work right now with the Peasant Rights Collective, primarily at the global level, we are working on some popular education materials for member organizations, along with a few NGOs in Europe. So my positionality means that not only am I researching the Declaration, I'm also considered a rights holder based on the wide definition of a peasant. So working across these contexts and acknowledging the rights violations here, particularly in the COVID context, made me want to explore further how we can relate this to the Canadian agricultural experience. So just a bit of context for the Canadian agriculture policy scene. The Canadian government did not adopt the Declaration on the Rights of Peasants. They abstained. And if you take a closer look at the current policies, you can really see why that is, in particular, why they would be opposed to the idea of collective rights. In kind of the post-World War II world to now, agriculture policy in Canada has shifted along the lines of a narrative of expansionism. So there's far less emphasis on livelihoods, rural communities, well-being, and more emphasis on profit. And this sort of rapid corporatization and liberalization of agriculture has led the policies to frame farmers more as entrepreneurs, as business people, and to kind of push farming in the direction of a business interaction. And this kind of raises a lot of red flags because farming is a unique livelihood built on relationships to land, to those who eat the food you produce, to your family, your coworkers, whoever you're working with, and treating it as a business operation really discredits these relationships and can cause harm when the profit-driven part of farming is the only aspect considered important to the policymakers who are being lobbied hard by corporate entities to ensure that their bottom lines benefit from Canadian farming activities. So this market-based policy regime really fails to integrate a human rights consideration and the ecological significance of agriculture. So the scale has tipped quite dramatically to one side in Canada, where the policy regime is really quite market-based. So what I've done in this slide, and kind of the focus of my research right now, is to look at a couple articles that I think are most relevant to the Canadian context. And as I was just saying, we're kind of at the market-based end of the spectrum right now, and the articles in the UNDROP are really tools to help try to balance, to bring the policies back to like a middle spectrum at least, because they kind of fall to the opposite end of the spectrum, rights-based versus market-based. In this way, a lot of the language of the declaration can be viewed as sort of legal remedies to the rights violations continuing to be perpetuated by the current policy regime. So I picked these articles kind of based on the current realities, and I don't have time to kind of dive into all of them, particularly the right to land, because it's just far too nuanced and broad to get into in this time. But in particular, I'll just focus on the right to seeds and the right to healthy working environments. So presently, the language that is engaged in Article 19, the right to seeds, is arguably the strongest language in any international treaty that advocates for farmers' rights to seeds. And in Canada in particular, seed sovereignty has been under attack for quite a long time. In 2015, the Plant Breeders' Rights Act was brought under UPOV 91, which opened dialogue around policy that imposes recurring royalties on farmers who save and reuse farm-saved seed. Therefore, they're commodifying a practice that has been ongoing for generations and disenfranchising these farmers from a long-held custom. So these changes would broaden the power of private plant breeders at the cost of these farmers. So, and simultaneously, there's been a huge withdrawal of resources from public seed research and development. So Article 19 reinforces that states should take appropriate measures to ensure that agricultural research and development integrates the needs of peasants and other people working in rural areas, and also ensures that seed policies, plant variety protection, and other intellectual property laws respect and take into account the rights, needs, and realities of peasants. So unfortunately, Canada is already failing to acknowledge its right to seed obligations listed in the International Treaty on Plant Genetic Resources of Food and Agriculture, the Declaration on the Rights of Indigenous People, the Convention on Biodiversity, and we're up against the reality that human rights are not granted primacy over intellectual property rights obligations. However, I think that the language used in the Declaration on the Rights of Peasants is a good rallying point for the sort of varied seed sovereignty movements in Canada, and there's already good examples of it being engaged in other countries. And the other article I wanted to draw attention to is Article 14, which discusses the right to work in a safe and healthy work environment. And I think this really came onto the radar in quite a frightening way this past year under COVID-19, when sort of the horrors of the conditions for migrant workers were really exposed. I think it's been something that's always been somewhat known, but kind of brushed under the rug in Canada. And the COVID-19 pandemic really brought to light, whether it's on farms or in packing and production facilities, just the abysmal conditions that many migrant farm workers are forced to work in. So the right to work and live in a healthy work environment is technically mandated by federal programs, by the Temporary Foreign Worker Program, by the Seasonal Agriculture Worker Program, but the provincial regulatory standards for businesses that use these programs are grossly lacking. So this is a context where the strong language in Article 14 would actually be a really helpful legal tool for advocates to create provincial regulatory standards. And then finally, Article 25 is of particular interest to me because it's the article that discusses the right to adequate training. And in Canada, unfortunately, the right to learn and to know how to grow healthy food is not a given, especially in an institutional way. So when you look at the majority of agriculture education in Canada, it's kind of a narrow education base that's primarily vertically and institutionally distributed, a sort of pipeline for conventional and industrial agriculture. But there's no like true alternatives that aren't directly tied to corporate funding, at least at an institutional level. And I know there are some programs about organic agriculture, but on the whole, the right to adequate training is definitely something that's underfunded and needs to be further researched in Canada. So what does this mean since Canada did not adopt the Declaration on the Rights of Peasants, yet there are clearly myriad rights violations ongoing with relation to agriculture policy, farmers, farm workers across the country. So the fact that Canada did not adopt it does not prevent us from engaging with the language in these articles as advocacy and legal tools. The fact that Canada did not adopt it is actually better reason to popularize the language and rights demands that it uplifts, because it's more relatable than policymakers would ever admit. So another question that I'm often asked by other folks in the farming community is just about the language of peasants. And I like to refer them to a quote by Nadia Lambek, who is a farmer in Saskatchewan, and she was past NFU president and was sort of one of the inaugural members of the Via Campesina, was there at its founding. And I really like, and I'm paraphrasing, when she defines peasants as people of the land. And I think in Canada, we are far more tied to this concept that we are people of the land than the idea that we're part of an industrial machine. And the concept of people of the land doesn't only refer to small subsistence peasants, because we actually face a lot of the same issues, whether that be land grabbing, the corporatization of agriculture, the severe lack of resources for rural areas. And perhaps farmers here won't readily change their language to refer to themselves as peasants, but seeing ourselves through this definition brings us under an umbrella of a shared struggle. And in this case, under the umbrella of the Declaration on the Rights of Peasants as a tool for change at the policy level. Fortunately, there's already a strong movement for food sovereignty in Canada. So really now the next step would be expanding the popular education around the Declaration and how to use it as the legal tool that it is. So my last slide, I'm probably over time. I'm sorry, Annette. I'm almost done. So essentially, just to kind of summarize my ramblings a bit more succinctly, the Declaration on the Rights of Peasants in Canada, I really feel can be an effective way to tip the scales away from a fully market-based approach to food and agriculture policy, and try to bring a balance by using the legal language it provides to fill normative gaps in protecting farmers and people working in rural areas. I think coalescing the food sovereignty movements that are already pushing for so many of these key rights kind of in their separate fields, using different language and different strategies, bringing those together is really key, because movement building is really our strength as kind of folks who are organizing from below and to the left, especially considering Canada's reluctance to acknowledge collective rights. There's also, and something that's really hopeful, is there's a lot of interesting work going on globally to engage with the Declaration on the Rights of Peasants at a policy level. In Nepal, which obviously has quite a different agriculture context than us, they passed a Right to Food and Food Sovereignty Act in 2018, and now they're in the final stages of ratifying a Peasant Rights Act, which engages a lot of the language from the Declaration on the Rights of Peasants. And Switzerland, which was a key ally of the declaration process, has vowed to implement it into its national policy. So I'm curious to see how long that takes and what form that will take. So I'm hoping that for myself, engaging in this country-specific analysis from an academic perspective can help me support and encourage others to do the same in other contexts, to try to get to know their current policy landscapes and see where the Declaration on the Rights of Peasants can fit in, particularly in countries, industrialized countries, like Canada that did not adopt the declaration, because I think it's still a very relevant tool. We just need to learn how to use it in different ways. Thanks for listening. And again, I am at the tip of the iceberg of my research, so I definitely have more questions than I do answers right now, but I appreciate you listening to me. So thanks.
All right, thank you, Jessie. That was great. So can I just hand it over now to Nadia, who is going to, really focus a little bit more on the farm workers issue.
Thanks, Annette. And I'm just, can everyone see my slides now? Great, okay. Thanks again, Annette, for including me in this exciting and important conversation. I'm calling in today from the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River, also known as Toronto. And I'm really going to build in my presentation on the presentations of Geneviève and Jessie to talk about another element of UNDROP, which Jessie already brought up, and that's its protection of workers, and how that might be relevant here in Canada, particularly with respect to the conditions that migrant workers face. So I'm going to start with just a brief overview of UNDROP's protection of workers' rights. Then I'll spend a moment on how we regulate farm work here in Canada. Then I'll speak about migrant farm workers during the pandemic, and I'll end with a case study, a court case that made its way through the system in 2020, relying on UNDROP to guarantee rights for migrant farm workers. Okay, so turning first to UNDROP and workers' rights. I think one of the groundbreaking elements of the declaration is, in fact, its inclusion of workers and farmers in the same document. Geneviève and Jessie have outlined some of the ways in which our dominant development and production and economic models have pushed unsustainable and unjust food systems that marginalize and subordinate some producers. But another thing these dominant food systems have done cleverly is to divide those who are dispossessed and subjugated by the system to make them feel in competition with each other rather than in solidarity, whether this is consumers and producers or producers and workers. And by placing the rights of rural people, including workers and producers, together in the same instrument, the declaration really signals that these groups face many of the same challenges. It positions their rights as part of the same resistance, I think, to cheap food systems and to industrial agriculture, rather than pitting them against each other. So Article 1 of the Declaration, which defined peasants, which is important, also includes workers. So hired workers, including migrant workers, regardless of their migration status, seasonal workers on plantations, agricultural farms, forests and farms, and aquaculture and agro-industrial enterprises are all included as rights holders under the Declaration. The Declaration builds on various international labor standards stemming from the International Labor Organization and other instruments to then delineate the rights of workers in a number of different articles and provisions. So a number of the provisions and articles concern the rights of individual and collective agency of workers. So this is like rights to join a union or to bargain collectively, and rights to choose one's work freely. And both of these rights, I think, are really central to individual and collective agency and to food sovereignty more broadly. The Declaration also delineates rights concerning conditions of work, like the Article 14 that Jessie already highlighted, the right to safe and healthy working conditions. And finally, the Declaration addresses the ways in which, for migrant workers, immigration status can be a barrier to realizing their rights. So for example, in Article 22 on the right to social protection, the language actually used to be stronger and it's been kind of whittled down during the negotiation process. But the Declaration states that social protection is to be available of migrant workers regardless of their immigration status. So turning now to how we regulate farm work in Canada. And I'll start with a caveat, which is that it's a bit complicated, in part because the structure of our Constitution divides jurisdiction over work on farms between the provinces and the federal government in a number of ways. So as a general stance, and I think Jessie's kind of already alluded to this, the law and legal institutions that regulate work on farms in Canada, and I'm going to speak about Ontario specifically because that's the context I know, really devalue agricultural work in significant ways, disempower workers, and often actively construct the workforce to be vulnerable. So, okay. Looking at the working conditions that farmers work under, that's a matter, as Jessie already alluded to, that's for the provinces. So many provinces in Canada have adopted agricultural exceptionalism into their labor and employment regulations. So turning again to Ontario, where I'm calling from, the employment standards legislation excludes farm workers and harvesters in a number of key respects. And it's a bit complicated. I've included a chart that kind of summarizes here, but basically, essentially, farm workers, there's no maximum hours of work that they can work. There's no rest periods legislated during the day and no requirement for rest periods in a week. So an employer can have an employee work for 14 days straight. That's not a problem without any breaks, without any overtime, and without any public holidays. And for farm employees, there's no minimum wage. Across the country, more broadly, thanks to a Supreme Court decision of Canada in 2011, farm workers do not have the right to unionize in Canada, and they can be excluded from provincial labor statutes. This is despite the court recognizing the vulnerability of farm workers in a bunch of significant court decisions, and yet there's no right to unionize. So the federal government then regulates migrant farm workers when they come to Canada, including how they might come to Canada. And the longest standing program to bring migrants into low-skilled occupations in agriculture is the Seasonal Agricultural Workers Program, or SWAP. It was first implemented in 1966 and functions to this day. It brings workers from Jamaica, from Trinidad and Tobago, from Barbados and Mexico. And it's quite a big program. In 2019, there were close to 47,000 positions in Canada through the program. About 40% of them are in Ontario, 32% in Quebec, 18% in BC, and about 3% in Nova Scotia. The program, I'm sure you've all read about it, has been heavily critiqued over the years by academics, by participants in the program, and by activists and lawyers alike. Some of the dominant critiques of the program are that it includes no pathway to citizenship or permanent residency, that work permits are tied to a single designated employer, and as a result, workers are less likely to complain about conditions, less likely to bring an action against their employer because they could be deported if they're no longer working for that employer. Again, there's no right to unionize. There's no institution at the federal level to investigate if temporary visa workers are unjustly fired. These workers are often housed on farms because of their rural and remote work, which leads to dependence on farmers for housing. And I think we've all read the news of some of the really deplorable conditions under which farm workers live in Canada. And there are numerous cases, again, in case law, in academic studies, from advocacy groups, there's numerous documented testimonies of workers that have been fired and then deported for refusing unsafe work, for being injured or ill, for becoming pregnant, for questioning their employer, for making a telephone call, for a number of things. It's important to, I think, note that this vulnerability and this marginalization of workers, farm workers, is 100% created by the laws and policies that are in place to govern them. There's nothing natural or normal about this. It's really the result of policy choices we've made collectively as a country. So I risk here repeating Jessie again, but the structural conditions under which migrant workers labor in Canada really created the perfect environment for COVID-19 to devastate these workers. And I've included a small collection of headlines over the past few months about the conditions that migrant workers have faced during this pandemic, about how the travel, how they get to Canada and the possibilities for exposure during that process, to the poor regulation and enforcement of migrant housing, to a lack of rights held by migrant workers, and the kind of perfect storm that this left migrant workers in. So there's not really statistics. We don't keep track of that in Canada, or at least in Ontario, of the number of farm workers who got sick. But Justice for Migrant Workers, an organization in Ontario, found that at least by the end of August, 1,300 farm workers had contracted coronavirus and 3 people had died. So how can UNDROP help? I'll end my presentation today with a description of what I imagine must be one of the first court cases globally to rely in part on UNDROP to guarantee the rights of agricultural workers. The case is Schuler Farms Limited versus Dr. Nadia Lambek, and it concerns the right of migrant farm workers to safe and healthy working conditions. So the facts of the case are as follows. As I mentioned earlier, many farm workers reside on the farms where they work in housing provided by their employer. In Ontario, this is often, for big farms, large bunkhouses. Early in the pandemic, the medical officer of health for the Haldimand Norfolk Health Unit issued an order requiring that migrant farm workers arriving in Canada past their 14-day quarantine period that was regulated by the federal government, that they do so in social isolation in a bunkhouse that had no more than 3 residents. So this added this condition of 3 residents on top of the federal standard. The region, this Haldimand Norfolk health area, is home to more migrant farm workers than any other health unit in Ontario. It also has the highest number of migrant farm workers per capita in Ontario. And it had one of the highest, or it continues to have one of the highest fatality rates of COVID-19 in the province. Schuler Farms then, on behalf of a few other farms, appealed the order, saying it was arbitrary and that it would inhibit their operations. As the case kind of moved its way up through the legal system, there were 4 main parties that participated. So Schuler Farms, which is a tender fruit and apple orchard in southwestern Ontario, represented a few farmers. The farm itself, it's quite a big operation. It has 220 migrant farm workers each growing season. The officer of health participated in the case, and then there were 2 interveners. One, a collection of organizations working directly with migrant farm workers, some legal clinics and advocacy groups, and another representing the Canadian Lawyers for International Human Rights, and I worked with those lawyers on that case, It's worth noting that migrant farm workers, and the farmers particularly at Schuler Farm, were not a part of any stage of the proceeding. They had no counsel. They were not given an opportunity to present their perspective or to give legal arguments, and they were not accounted for in any particular manner that recognized their agency or voice in the proceeding. So the case proceeded through a number of levels of courts before arriving at the divisional court in Ontario. The court, early in its decision, recognized that migrant farm workers are exceptionally vulnerable because of their immigration status, their race, and their precarious employment relationships that are imposed by the structure of the programs under which they are imposed. In determining whether the order of 3 per bunkhouse was arbitrary, the court then turned in part to international law. And the court stated that as a matter of statutory interpretation, legislation in Canada is presumed to comply with our international obligations. So courts must interpret domestic laws in a way that reflects the values and principles, in this case, of international human rights law. So although Canada abstained in the UN vote to adopt UNDROP, and although we have no legislation implementing UNDROP domestically in Canada, the court held that UNDROP is part of the body of human rights law and norms to which Canadian adjudicators should look in interpreting statutory or common law obligations. The court went on to detail that the International Covenant on Economic, Social, Cultural Rights and UNDROP provide that everyone has the right to the enjoyment of the highest attainable standard of health, of physical and mental health, and that that applies regardless of national origin, race, or other status. They also extended, they also noted that this right extends to the determinations of health, including adequate housing and healthy occupational and environmental conditions. The court stated then that the state, here Canada, had an obligation then to regulate third parties like Schuler Farm to ensure that the right to health was realized. Relying in part, they relied on many things, on these international law principles, the court found that the order for the 3 to a bunkhouse was in fact reasonable and that workers had the right to quarantine in conditions of proper social isolation. It ordered that the farmers in this region ensure this separation going forward. The order, although it was appealed, the appeal was dropped, and so it continues and will regulate the housing of workers this summer. I think this case illustrates just one of the many ways that UNDROP might be able to extend, promote, and help realize the rights of people living and working in rural areas, and that it's an interesting case for us to turn to as we continue our advocacy. So I've gone way over. I'm going to end there. My apologies, Annette, and thank you.
Thanks. No need to apologize. Thank you very much. At this point, I'm just wondering if we can, I mean, I thought we would have time for the panelists to ask each other some questions, but I'm wondering if there are any questions from the audience. And if there are, could you maybe place that in the chat? I did notice that earlier on, there was a question, I think, posed by, it wasn't a question, it was a statement by Haroon on, you know, the possible conflicts with between UNDRIP and UNDROP, the UN Declaration of the Rights of Indigenous Peoples, and the one that we're talking about today. And maybe Jessie, you could maybe talk a little bit about that.
Sure. Well, I'll just say quickly that Article 28 was a later addition to the declaration, and I posted about it in the chat a little bit further up. I just copied and pasted the article, but essentially it ensures that, as with other UN declarations, this declaration does not override or diminish previous human rights instruments. So in effect, the Declaration on the Rights of Peasants would not inhibit the implementation on the rights of Indigenous peoples, which Canada did actually vote in favor of. And after the vote at the UN General Assembly in 2018, where Canada abstained, they actually told me that one of the reasons they did not vote in favor was because they were too busy working on an implementation plan for the Declaration on the Rights of Indigenous Peoples, which remains to be seen.
Okay, I do see that there is, thanks for that, Jessie. I just saw a question here. What could agrarian reform entail for migrant workers? I'm assuming that would be in Canada, or are we talking internationally?
To clarify my question, thank you.
Yes. please.
Agrarian reform in Canada has to be matched with agrarian reform in other countries, right? Because one of the arguments of employers is, well, the workers don't have stable income in their countries. So international solidarity is required, right?
Okay, can I ask any of the panelists to, if they wish to respond, please.
Well, I don't think. I don't think any country has to wait for another one to expand good laws and good regulations for the land, especially. Of course, there is always this question of unfair competition, but competition is unfair anyway. So in Europe, for instance, the question of land is not a European issue. It's not a European Commission issue. It's not in the treaties. So each country has its own regulation for land. It can be very, very organized, for instance, in France, not so much in other countries. And all between countries, you have this competition law that normally forbid national laws to go against, I don't know, foreigners or people from other countries buying land. But that's all. Otherwise, it's national. The organization of land ownership and land lease and so on. It's national. So, and for the moment, it hasn't changed. ECBC is trying to have a directive at the European level to have more direction, to make sure that there is not so much artificialization of land. But for the moment, it's not achieved yet. So I don't think there is a need to have a same thing in every country. And
okay, thank you, Geneviève. Jessie, did you want to add anything, or Nadia?
I just Tyler, that I think that's a challenging question to answer because it depends on whose agrarian reform and the extent of our imagination and commitment to different actors. So I think you could have agrarian reform that took migrant farm workers, like the ones in Canada who have been coming for 2-3 decades now, and had agrarian reform that really provided them some sort of status in Canada, but access to land. And then you could have very bad agrarian reform that marginalized people, that violated Indigenous rights in a bunch of serious ways. So I think it's a question that requires reflection and thought and would depend on who's coming up with the agrarian reform, whose rights they privilege over whose, and what implementation looks like.
Right. Well, Jessie, did you want to add? Okay, I guess I just want to add that, I mean, certainly in the case of Canada, land consolidation, land concentration is a huge, huge problem, and it's becoming increasingly important. So, even the idea of land reform is in Canada is absolutely revolutionary. But it's certainly something that we need to look at very carefully and in the near future if we want a new generation of farmers, which, should, if we could stretch our imaginations a little bit, should include farm workers or giving them access to land. Okay, we only have about 3 minutes left, and there is one question that, and I'll just read it out, okay? I wish I was more familiar with UN proceedings, but if Canada wanted to change their stance on UNDROP, would the abstention allow to vote in favor later on, in favor retroactively? Or does Canada need to wait for another official vote to be called?
I can take that one.
Sure.
So what Canada votes on UNDROP is really not dispositive of anything in terms of of the rights that people have here in Canada. Declarations, unlike covenants, are not binding on people or on countries in the same way. So there's nothing, you can't really accede to the document like you can to the international covenant. So if Canada wanted to make UNDROP real, it would adopt domestic legislation, adopting UNDROP into our domestic system. That's how Canada would make it real, not really voting. I mean, it's symbolic whether it votes in favor or against at the UN system. If the vote had been closer, it could have been a bigger deal. I think it was disappointing to a lot of those who advocated for it in Canada. It sent a message, but Canada could right now adopt legislation making UNDROP real domestically. And as I noted in my presentation, the courts, regardless of Canada voting in favor or against or abstaining, can still rely on UNDROP when they're interpreting domestic legislation in a court case to determine somebody's rights. So I think it's a great question, and it's really disappointing, the position that Canada took, but it doesn't mean it's the end of the road for UNDROP here. And maybe Jessie wants to add, but that's a quick answer.
Well, I'll just say, definitely one red line issue for them was the idea of collective rights, because other than language rights in Canada, the concept of collective rights is not widely accepted. So I feel like that is probably something that will continue to mean that Canada will not change its vote. And I mean, at the UN level, I don't see that happening. But again, I think, as with what Nadia said, like really legal advocacy in Canada is the only way that we'll see it actually move its way up through the policy system versus like the top down, because there's very little political will to move any sort of collective rights forward.
And maybe just to add on to that, same with economic rights. We don't say anything specific about economic rights in our constitution, but the court's been very kind of adamant over the last 30 years not to define that we have any economic rights in Canada. So some like rights to seed, right to land, we would need to do work in Canada before I think the government would adopt anything with a kind of redistributive economic right attached to it. But our constitution doesn't preclude it. It's just that the courts have said it's not time yet.
Okay, I know we're over time, but somebody has just pointed out to me that I missed a hand that was up. So Haroon, can you go ahead and ask your question?
It wasn't a question, Annette. It was actually just a clarification. The reason I raised the UN rights, the Declaration on the Rights of Indigenous Peoples, was not to suggest that there could be any conflict between UNDROP and UNDRIP. What it was actually to say is one of the reasons Canada would not vote in favor of the UN Declaration on the Rights of Peasants is because of Article 17 and a collective right to land. Because if Canada were to vote in favor of a collective right to land, that would be seized upon by Indigenous groups here in Canada struggling for land justice. And of course, Canada is trying to adopt the UN Declaration on the Rights of Indigenous Peoples in a way which allows it to override certain clauses within the declaration, particularly collective rights to land. This goes to the heart of some of the central questions facing the country, and it really does explain why a Canadian representative in the UN would never vote in favor of collective rights to land. That's all.
Mm-hmm. Yeah, really, really important contribution. Thanks for that, Haroon. Okay, well, I want to thank the three speakers, Geneviève, Jessie, and Nadia, for helping us all get a better sense of what UNDROP is all about, what it entails, how it can potentially be used presently and in the future in our huge struggle to try to dismantle this global corporate food system that we desperately need to change if we're concerned about the planet and about social justice and ecological justice. So thank you, all of you, for tuning in. If you have friends that you think might be interested in the video, the YouTube video, just let them know where they can get a hold of it, which will be under you can search the Center for Human Rights Research. Okay, thank you once again, everyone.
Thank you. Good.
Thanks, Annette.
Okay,
Goodbye.
bye.
Goodbye.